So good afternoon, everyone. For those of you who haven't joined us before, I'm Diane Hoffman. I'm a professor and I direct the Law and Healthcare program at the University of Maryland Carey School of Law. And I'm very excited to see so many of you join us for the premier talk of the 2023-2024 Rothenberg Healthcare and Policy Speaker Series. Today's talk sets the stage, we hope, for this series, which is on the topic of legal and ethical issues coming out of the application of artificial intelligence in healthcare. And we are especially honored to have with us today and to start us off thinking about this topic, Professor Glenn Cohen from Harvard Law School. And I'll introduce Professor Cohen momentarily, but first I want to share a bit about this virtual series. The Rothenberg Healthcare Law and Policy series grew out of a desire to continue to bring excellent scholarly topics to our health law community when we transitioned to a virtual format in 2020 during the COVID-19 pandemic, and has since become a wonderful venue for our health law faculty, our students, our alums, and as well as colleagues in health law, bioethics, and health policy at other institutions to connect and to learn together virtually. The series was established with generous funding from the Karen Rothenberg and Jeffrey Seltzer Law and Healthcare Program Endowment. Professor Rothenberg was a former dean of the law school, as many of you know, and she was also the founder and directed for many years the Law and Healthcare Program. The series more generally focuses on current issues in healthcare law and policy. Past year's themes have included health inequities that were exacerbated by COVID, legal issues surrounding genomics, justice in health law, and last year, reproductive rights after the Dobbs versus Jackson Women's Health decision by the Supreme Court. As I said a little earlier, this year our focus is on AI and healthcare. And in addition to Professor Cohen, joining us later in the academic year will be Professor Nida Farahani from Duke University's School of Law, who will be speaking about AI and our brains based on her recently published book called The Battle for Your Brain, which addresses the promises and perils of AI access and modification to our brains. She will be followed by Dr. Vardit Ravitsky, the newly appointed Hastings Center president and CEO, who will discuss a new Hastings Center National Academy of Medicine initiative on healthcare artificial intelligence code of conduct. So much to look forward to. We'll also have a fourth speaker, but that I always leave as our surprise speaker. But our speaker for today, and the reason that all of you are here, is to hear Professor Cohen. Professor Cohen is the James A. Atwood and Leslie Williams Professor of Law, Deputy Dean of Harvard Law School, and he also is the Faculty Director of the Petrie-Flom Center for Health Law, Policy, Biotechnology, and Bioethics at Harvard University. Prior to becoming a professor, he served as a law clerk to Judge Michael Boudin of the U.S. Court of Appeals for the First Circuit and as a lawyer for the U.S. Department of Justice, the Civil Division appellate staff, where he handled litigation in the courts of appeals and in conjunction with the Solicitor General's office in the U.S. Supreme Court. Professor Cohen is one of the world's, I would say, leading experts on the intersection of bioethics and the law as well as health law. He has advised the U.S. Vice President on reproductive rights. He's discussed medical AI policy with members of the Korean Congress, and he's lectured to legal, medical, and industry conferences around the world. His current and recent projects relate to medical AI, mobile health, and other health information technologies. Abortion, reproduction and reproductive technology, the therapeutic use of psychedelic drugs, research ethics, rationing in law and medicine, and health policy, FDA law, and more. And he is the author or the or the co-author of more than 200 articles and book chapter, and his award-winning work has appeared in leading legal, medical, and bioethics journals, as well as the popular press. We are honored to have him with us today to discuss medical AI, regulatory, and ethical challenges. Before I turn turn the podium over to him, I wanted to say that if you have questions for him while he's speaking, please don't hesitate to type them in the chat. We won't get to them probably until the end. After he's finished speaking, we can take additional chat questions, so don't be shy about doing that. Thank you so much to all of you for being with us, and with that, I will turn things over to Professor Cohen.
Thank you so much for that incredibly warm welcome. And what I like to say is it's a huge honor for me to see Dean Rothenberg here and to be introduced by Professor Hoffman, in part because, as I like to say, when I was just starting out, we were talking about this 15 or 16 years ago, when I was trying to get my first job and I was just, to use the Yiddish vernacular, a little pisher on the market. They were incredibly kind, incredibly great mentors to me and wonderful people. And it just reflects so wonderfully on them and also the community in health law. Okay, so hopefully you can see the slides. I'm going to talk about 30 or 40 minutes. I looked through the people who are participating and it's so exciting to see so many of my friends from law schools and also bioethics departments. Hopefully there'll be something for everybody in this talk. Let me start with just the disclosures. These are some of the things I'm doing that might be relevant in terms of making sure that I am disclosing conflicts of interest. Okay. I want to start here. So Tom Robbins, the American novelist and satirist, once said, "There are two types of people in this world. Those who think there are two types and those who know better," right? So I like to think of myself as somebody who knows better, but still I'm going to try to divide the world into a few types over here. And this is a division that was suggested by my friend Nicholson Price. One way of dividing the world in medical AI is by function. What are we trying to get AI to be used in? Imaging has been a very low-hanging fruit. Prognostics, predicting the health needs for a particular person in the future. Diagnostics, knowing what's wrong with a particular person. Treatment, using AI to determine which among a series of possible treatments is the one to go with, for example. So this is one way of dividing the world. But a second, and I think complementary way of thinking about it is purpose. What is it we're investing in AI to do? Why do we want to have AI at all in this space? And you could apply this to any of the function categories. So one thing is just democratizing expertise. So take AI dermatology. Everybody could get access to a good dermatologist expertise via AI, and that might include uninsured individuals, people in the developing world. Automating drudgery. Physicians spend a lot of time on paperwork. Could we free up the time of great dermatologists by automating some of that, including perhaps patient reports? Optimizing resources, choosing among a population of people that is hoping to see the dermatologist, who gets priority and why. And perhaps some people might be served by an AI agent at least first before they see the dermatologist and see if that resolves things. And finally, pushing frontiers, improving how excellent dermatologists perform their job, computer-aided dermatology to help dermatologists distinguish from benign from precancerous in a much better way than currently. So part of what's interesting is that most of the hype cycle and also a good amount of the investment cycle is in that last box of pushing frontiers. But in fact, if you ask me as an ethical matter where I think the most value is, it's probably that first box of democratization of expertise. So this is a little bit of a walk before you run point, that if we could take some of the expertise we have now, very good dermatologists, and just scale that up through AI, that would be a huge, huge benefit. And maybe we're not thinking enough about that category. Okay, so now just to be a little bit tangible, let me give you some sort of use cases that you could imagine. One would be using AI to determine which among a family of possible cancer therapeutics, chemotherapeutics, for example, to prescribe to a patient by focusing on facts about that patient. There are EHR data, genetic testing, family history, but also environmental factors. Another, perhaps more controversial, would be trying to help a physician decide whether to send a patient with a moderate organ dysfunction to the ICU. The ICU beds are very precious, so which patients should be prioritized? Another example would be, and I recently presented to fertility specialists who are starting to do this kind of stuff, determining how much dosage of FSH, follicle-stimulating hormones, to give to a particular patient for egg retrieval for ovarian stimulation and adjusting it for the particular patient. Another example might be using AI to rank particular embryos for likelihood to produce pregnancy. So there is some paper suggesting this is something we could do with embryo microscopy images and then help a physician decide which embryos to implant. And then I once talked to echocardiologists and they told me this was something that we're very excited about. I had no idea what it meant, but I thought I would include it nonetheless, which is echocardiographic quantification of left ventricular ejection fraction. That this is something that they're using AI to do, or it's been proposed. All right, those are some use cases. Now, this is kind of my master slide about like what everything that could go wrong you should think about as an ethics matter. We'll zone in on some of them law stuff in a few minutes, but I just wanted to give the overview. And I often say this is like the 4 stages of building an AI ML model, artificial intelligence, machine learning in particular, a subset of AI. But like how maybe like, a poet would describe how a car engine works. This is how a law professor and ethicist describes how you build these kinds of models. So I think it's often in a way that makes sense to me, but it's not exactly the way they would describe it. So the first phase is just a question of acquiring the data. There's tons of issue just here in determining what data to use and how you get it. Do we need to explicitly consent patients for the use of their data to build medical AI? Does it matter whether we've stripped it of the 18 HIPAA identifiers, for example? Can we do this by a front door consent when you get care at a particular hospital or a particular doctor's office for the first time? Or is that too broad or too general? Do you need to reconsent individuals periodically or for potential future uses where you might think they have concerns? Then there's the question of just the quality of the data. How representative is the data? Of course, if we leave out racial or other minorities, the model's predictions will be off for them, which might hurt them or benefit them in some cases. Can you statistically correct on the back end for this problem? If not, what kinds of resources or carrots do we need to incentivize the collection of more widespread data, or sticks to punish companies that don't have representative data? And then just a question about governance. What role should patients have as governors of their healthcare data? Should data sets be treated by the law as trusts, for example, with a trustee and an executor and fiduciary duties? Should we think about this like a union, that you're in a union with other people who've contributed data? How can this become meaningful rather than merely just a paper requirement? That's all in the first phase. The second phase is just building and validating your model. How do you know if your model works well enough that it's ready to be used on real patients? Who decides the standards of validation? Is it going to be risk classified? Can we know ahead of time about what the effects of putting one of these models into place is in a hospital system beyond what it does in the particular task we've given it? Who's going to do the validating and how do we manage tensions between, for example, the desire for transparency on the one hand versus the fact that these models, typically the algorithms themselves, are not patentable, such that the best IP protection may be trade secrecy, which pushes against transparency? How do we think about the parties, third parties auditing, or perhaps the government involved in auditing what's being done with these models? Then we have phase 3, which is testing these models in real world settings. What, if anything, will patients be told about the fact that AI is being used to partially direct their care? I'll come back to that in a moment. Do we need separate informed consent for the use on patients? Could patients opt out? And does it depend on whether it's a strategic question like opting out on the use to determine whether you get an organ where actually the AI may disfavor you and so you have a reason to opt out? What about when analytics is in the background directing physician or nurse time, a kind of invisible allocation? And how should we think about all of this compared to decision aids or other sorts of things? There's also questions about liability. I'll return to that in a moment. And there are difficult questions about model implementation versus model design. So choice architecture. How easy should it be to override the model? Who should get to override the recommended decision? Do insurers have a role here? And which regulator or regulators are best fitted to oversee this area? In the US, I would say FDA has traditionally been somewhat allergic to regulating software. That's changing a little bit. But it does raise interesting questions about whether we need a more widespread AI regulator or whether a health regulator is the one to do it. Finally, broad dissemination, the last phase. Congratulations, you're successful. You've produced AI that works. It's helping many people with breast cancer or getting pregnant or whatever it is you want to do. And then the question is, who has access to it? The model is built on the data of so many people, basically people across the United States or across the world. It's a problem, I think, a problem of equity if the only people who have access to it are people who go to expensive academic medical centers in large urban areas. What role for government and for all of us in ensuring equitable access? What does equitable access look like? How do you accomplish that? Okay, so that's the big overview. Now I'm going to take just a few pieces of it and talk about it in greater depth. And the first one I just want to point out is often when I present this to non-health people, first thing they say is AI is a general problem for society. How is anything you're going to tell me different from driverless cars, for example? And I got asked this so often that I made this slide to try to illustrate. What I want to emphasize that's distinctive about the healthcare setting is the number of parties that are involved between the AI and then me as the patient. And this busy diagram actually oversimplifies things in a sense, because there should really be arrows from each of the spokes to one another, not just to the hub. But in thinking about how AI might make my life as a patient go better or worse, there's tons of different people who are involved. There's the AI developer who makes a ton of choices beyond the underlying algorithm. Will the algorithm be a learning algorithm that learns on the job, an adaptive algorithm, or will it be locked to its factory setting? What's the choice architecture about how it's built in and how it's overridden? We have a regulator like FDA who might review pre-market some kinds of algorithms, but not others, for example. And that might turn on things like whether it's built into a device that's an SAMD or not, but that might not really be what's meaningful to a patient who cares a lot if the algorithm is just running in the background at a hospital system. It could be purchased by a hospital system who has to decide how to validate it and whether to use it, or the hospital system could co-develop using its own electronic health records, or even develop it in-house, in which case it might have other incentives beyond merely choosing an algorithm that's best for its patients. The hospital system might in turn impose the AI on a physician user, or physicians might themselves choose to purchase it for their own non-hospital practices. And those decisions, whether to purchase it and how, might impose AI on nurses and others. And here we have differences in terms of the way the law treats them. For example, employees, unionized, independent contractors. Then we've got insurers who have multiple roles to play here. As payers, they might decide whether to reimburse the hospital for its purchase of the AI itself. They'll also make decisions as to whether to reimburse only what the AI recommends in terms of treatment or not, in which case the reimbursement rules will affect the likelihood that a physician will deviate from what is in theory a free choice of a physician. And so what I want to show just with like this level of complexity is that it's really tricky, because if you try to solve the problem at one level, you might exacerbate the problem at the other levels. And so as you think about this, much more so than driverless cars, where we have the car company, we have me, the driver who's bought the car, and we have other drivers and pedestrians. I can much more easily specify what looks optimal as between that three-party arrangement. With like 8 parties, my head starts to hurt. And I think that we all kind of going to struggle with this. And it's worthwhile for us to lean into the complexity rather than prevent it doesn't happen. Okay. So now this slide is mostly for the non-lawyers in the room, which is kind of like a torts 101 or medical malpractice 101 as applied to artificial intelligence in medicine. And this is from a paper I did with Gurka and Price and JAMA from a few years ago. And what I want to say is we have actually very, very few cases involving medical AI that have resulted in published decisions. Hard to know what to make of that. Maybe it turns out it doesn't hurt people a lot of the time, or maybe all those lawsuits get settled, or maybe they're too complex to bring. But it's useful just to understand what could happen if you use a medical AI. So we have a very stylized and simple example here. And essentially the example we have is a physician trying to decide which of 2 chemotherapeutic doses to administer for ovarian cancer. 15 milligrams per kilogram every 3 weeks, which would be the standard of care dose, or a higher dose for this particular patient. And the idea is the AI might recommend, in some of the instances, the non-standard of care dose. That's the second column from the left. When the AI does so, and now this is the third column, the AI could either be correct or incorrect in the sense of this is a dose that actually produces a good effect or an adverse event for this particular patient. One of the promises of medical AI is towards personalization. So we should leave open the possibility that for a particular patient, the standard of care dose is not optimal. Next, the fourth column. The physician could either follow or reject the AI recommendation. In this example, we're assuming the physician has discretion, but in the future, a health system or a payer could limit that discretion. Then the next column represents the outcome. What happens if the physician follows a correct recommendation or rejects an incorrect recommendation? The outcome is good. If the opposite, the outcome is bad. And again, this is a super stylized example. And then we get to the final column, which is like traffic light colored, right? There are good cases, so-so cases, and bad cases in terms of liability. First, if there's no injury, there'll be no liability. That's a basic rule of tort law. And that's a good outcome, whether it happens because the physician accepts a correct recommendation, that's box 1 and 5, or because they reject an incorrect recommendation, that's box 4 or 8. But second, and this is something I think non-lawyers don't realize, is that tort law typically privileges the standard of care regardless of its effectiveness in a particular case. That is, regardless of whether it leads to a good or bad outcome. So you as a physician, if you want to know what's the most safe thing I should do from a liability perspective, you're only going to face liability when you do not follow the standard of care and an injury results. That's the red box. Now, that means, though, that your incentive from a deterrence perspective, from a legal perspective, a liability perspective, is to use medical AI as a confirmatory tool to support existing decision-making processes rather than as a way to improve the care. That's all well and good, but if the whole pitch of medical AI is it's going to help physicians do better in precisely the cases where the standard of care is not the right thing to do, suddenly we have a tort system that's working at counter purposes to that. Now, could we enter a future where failing to use medical AI or follow it becomes a deviation from the standard of care? It's possible, but I will tell you that tort law is fairly conservative in terms of standard of care. We have like the respected minority and the like, those kinds of rules, such that such a shift might require kind of an outside push from legislatures or possibly from the organizations of physicians, because allowing tort law to do it on its own will not get us there anytime soon. All right, that is physicians. Now I'm just going to say a little bit more about the institutional level. So we have a law review article coming out soon in the DePaul Annual Tort Law Symposium, Nicholson and I, on developer and enterprise liability, so hospital liability. And here we say that we think that these are not great solutions at the moment for the problem of medical AI. We think developer liability runs into two problems. First, the courts have been pretty hostile to treating software as a product. And second, and we think more normatively, developers have a real information problem that leads us to think that in many instances, they're not going to deter or make decisions in a good way. Put simply, they lack the information about the workings of the hospitals where their systems will be deployed. They don't know the details of the patient populations. They don't understand hospital workflow functions or practice, how data structures can change over time, and therefore they're not going to be the ones making wise decisions. On the flip side, what about the hospital system? Should we hang liability on them? Well, there are derivative and direct liability theories against hospital systems that might be possible. For examples, you might try to draw analogies to negligent credentialing or supervision and say somewhat anthropomorphically that the AI is hired instead of bought, and that the hiring, they didn't do the right credentialing process, like getting information on products. Now, we think, again, that this is not a great solution for a number of reasons. First of all, we think you really have to stretch the doctrines to get there. The second is that the hospital systems are often going to have a hard time getting the exact kind of information that we think they need in order to know whether this is wise to use. So getting information on products, some of which are trade secrets, and understanding performance and the interplay of general model performance with specific patient populations. For that reason, and we can chat more about the Q&A, our solution, but it's a very law professorial solution, which is to say, good in theory, probably not going to happen. So I'll just put that out there. But good in theory, hopefully, at least we get part of it true, which is to say that we think the right rule would probably be to have enterprise liability on hospital systems where they are broadly liable for negligent injuries occurring within the hospital system when it comes to AI, but with a caveat that the hospitals have to have access to information needed for adaptation and monitoring. And if that information is not available, we think the liability should shift from the hospitals to the developers keeping the information secret. So the idea here is to have a shifting default that penalizes withholding the information that's needed for good decision-making in this space. I do want to say that although we have this proposal in this paper, a lot of this could also be achieved by contract, by private ordering, through indemnification agreements between developers and hospitals on the one hand, and various contractual provisions with the hospital system on the other. We're seeing a little about this in the market. So Michael Abramoff, whose company made IDXDR, one of the few quite autonomous medical AI products, does apparently offer exactly this kind of contractual indemnification. But we don't know, we don't have visibility, Nicholson and I, into whether this is going to be the thing that the market does in general, whether this is a one-off. Okay, so in the next little bit, I'm just going to ask you to do some audience participation for a second. I'm going to play a clip in a second, and I can't see the chat, so I might, I'm not going to see the chat now. So I'm going to ask you all to use the chat to answer the following question. I want you to listen to this clip, and literally I want you just to type in a few people, whoever wants to, what they hear at the end of the clip. You ready? This is the audience participation portion. Okay, we're going to hit play.
See, how may I help you?
Hi, I'd like to reserve a table for Wednesday the 7th.
For 7 people?
It's for 4 people.
4 people when? Today? Tonight?
Next Wednesday at 6 p.m.
Oh, actually, we reserve for like upper 5 people. For 4 people, you can come.
How long is the wait usually to be seated?
For when, tomorrow or weekday or?
For next Wednesday, the 7th.
Oh no, it's not too busy. You can come for 4 people, okay?
Oh, I gotcha. Thanks.
Yep. Bye bye.
Okay, so have at it in the chat. Type what you heard. Byron says AI. Okay, what do people say? Go ahead, just describe what you heard. Not AI, says Jennifer. They already know that the question's gonna be AI or not AI. AI. But like, imagine I mean, again, the slide says informed consent to AI use, but big hint here, right? But if I just played this to you, right, it would sound like any other phone call, a reservation, or something like that. This is, in fact, so getting AI, not AI, not AI. For those who are saying AI, who do you think the AI is? Anybody want to type? The man, the woman, the person calling, the man, man. Yeah, okay, now we're getting a lot of the man now that I prompted you in that respect. In fact, the AI is the man. This is Google's Duplex, which is actually one of the first AIs to pass like a limited Turing test in this context. And that's great. I make reservations all the time. I'd love to have this on my side, right? But what I want to use it as is just the opportunity to kind of explain and to demonstrate in a very simple way that we're entering a future where we may be dealing with AIs much of our lives and have no idea we're doing so. And that raises the question about whether we have a right to know when we are dealing with an AI and how the law might translate that right into reality. So I also have this image of this cute little seal, which is Paro, the therapeutic robot. He's a form of social robotics. He's been given to people in, nursing homes with dementia, and they love him and they cuddle him and they think he's a pet sometimes. And it turns out he's a little spy because he's reporting back all sorts of information about them to physicians that many people don't understand. Then we've got chatbots. We had an instance with this with ChatGPT and Wobot, but ChatGPT much more easier to create these kinds of things with large language models that basically are giving individuals information and giving responses in mental health or suggesting prompts that someone chooses from, where somebody is saying, I'm having a suicide moment, and essentially they're hearing back suggested responses from artificial intelligence. How do we feel all about this? What should the law say about these kinds of circumstances? My own view is that it's actually a fairly difficult question about whether the law on informed consent should include a right to be told that an artificial intelligence is involved in your care. For example, the distinction between deciding between watchful waiting on the one hand or prostatectomy on the other, if you have prostate cancer. Is artificial intelligence in this context more like your physician not telling you that the reason they recommended this particular procedure was memories of something they read in JAMA and how you remind them of 7 other patients they recently saw that they did the same thing for? Is it like that where we don't think it's a breach of informed consent? Or is it more like your physician failing to tell you that a substitute surgeon has scrubbed into your surgery and is performing the surgery? For that, we have a case law telling us that is a violation of informed consent. So wrote a whole paper on this and happy to talk more about how to think about this. Okay, it's going to play again, but I'm going to jump here. Want to talk briefly about privacy. I mentioned this at the very beginning. Where does the data to train models come from? And is it a problem if we don't explicitly ask patients to share it? This is not just a theoretical question. We've seen lawsuits, the dinner seat lawsuit, for example, against the University of Chicago and Google, putative class action where it was alleged that by releasing EHR data with a timestamp on it that was otherwise de-identified, that allowed Google, with its ability to geolocate certain patients based on phone data because of Android phones, to basically determine which patients it was and where they were at that particular moment, and that violated HIPAA. There have also been, for example, lawsuits suing Cerebral and others about using the Pixel technology to share information as violating the statute. And part of what's interesting here is that with artificial intelligence, this is my attempt to show you, HIPAA is everything above the waterline. And we used to think that when you wanted to protect health privacy, once upon a time, you protected that which was protected by HIPAA. But we're rapidly entering a future where it's all the stuff below the waterline that is actually going to be just as predictive of our health. Our shopping habits, right? Our Fitbit data, our website browsing, all of these can help us predict our health. You look at how someone's Instagram filter changes over time and the decisions they make has had very good prediction of mental health states and depression. And we're entering a world where it's possible that all data will become health data. And then the question would be, do we need to protect all data at the level that we do health data? Or do we need to have just a general data privacy regulation like we do in the EU? And again, we can talk a little bit more about this shortly. I want to say a word about bias. And here I want to say that there's a version 1.0 of the bias problem that's easy to understand but hard to fix, and a version 2.0 that's much harder to even understand. The easy to understand version, and I alluded to this before, is data set bias. I, as a white man in my mid-40s living in Boston, I am dead center in every medical data set used to train medical AI in the United States. Great for me. If I am a young Black woman living in the South, or I am somebody of indigenous, I'm an indigenous person, much less likely that it's going to know and understand me and what's different about me. As a result, we have this problem where the data sets are biased, and therefore they're unable to do good predictions for an important swath of the population. That's a hard problem to solve, to fix the data sets, to get the collection to be better, but it's an easy problem to understand. This problem that was kind of reflected, I think, in a very good paper by Ziad Obermeyer and others that I have up here, is a much more subtle problem, but one that's much more pernicious. They looked at a high-risk management program that looked at patients that had been released from the hospital and decided who to follow up from, and it was being used by major hospital systems. The goal is to find your highest need patients and give them the most TLC on the back end to try to avoid hospital readmission. And what was interesting is the data that was trained on was lots of very robust data, but they purposefully omitted race to avoid having racially discordant effects. Then what these authors did is they looked at the actual performance of the algorithm. What do they find? At the same level of algorithm predicted risk, Black patients have significantly more illness burdens than white patients. That means that, in fact, it was favoring white patients over Black patients compared to what it would do if we were just looking at who was sicker. That's interesting. Why did that happen? Turns out it was a design decision that ex ante seems fairly reasonable, and that was to use healthcare costs as a proxy for health status. It's a very continuous variable. We have good data. And if we tell the algorithm to predict healthcare costs, what happens? Turns out at the same level of health need, Black patients cost the system much less than white patients because of differences about care-seeking behavior, geography, where they live, needs, and the like. So by making this decision very early on to use healthcare cost as the proxy, which I think ex ante was a fairly reasonable decision, all of a sudden we get this incredibly racially discordant effect. And that is just to say, you can keep looking for this. You can look for Black-white discordances, but think about all the other discordances you might have and all the other effects that are unintended, and how difficult it is to think through the logic on the front end of all of these choices about how you're designing the prediction. That suggests to me that the problem of bias is going to be an extremely pernicious one, but one that is much harder to solve. I can't just tell you, here's a template of what your data should look like, do these things. Instead, I have to train your data scientists to really troubleshoot and to talk to the population and to run simulations, but then also to monitor as we go. And that's just a much harder problem to solve. Okay, I think I made 2 more slides and then I'll subside. This is just a slide to say, the EU, a bunch of other places, very excited about requiring explainability. Their big fear is the black box model, black box medicine. And they say the solution is to require algorithms to be explainable. Turns out what we mean by explainable is often confused. An interpretable model is a model that can basically be easily traced back to a simple input-output function, right? So things like linear regressions are a great example of an interpretable model. That's different than what's sometimes called a white box model, where essentially you want a second algorithm fitted to the data that's the output of the black box model. And then you say essentially, this is what the model is doing. So trying to explain what a model is doing instead of building a model based on what you already understand and explain. This idea of explainable AI is attractive as a way of solving the problem because in medicine and many other spaces, interpretable models are less powerful. They can't do some of the really sophisticated stuff we want, the deep learning. And so people say, let's have our cake and eat it too, and let's use explainable models. And in this paper and some follow-on work, we basically try to show that's not going to work for some subset of cases. And the reason is we think that these explainable models, these white box models, are kind of fool's gold. They're ersatz explanations, if you will. And the easiest way to describe this is to picture me as a young man going to a club on a Saturday night. And I go to the club and I'm wearing sneakers, and the bouncer tells me, you can't come in, you're wearing sneakers. Turns out that actually the reason why I can't come in is I'm a guy and I'm with 3 other guys, and there's way too many guys in the club already and not enough women. And so the real reason is that in fact it's my gender. It has nothing to do with wearing sneakers. But it's true that the sneaker explanation does fit the data. That's the problem with these kinds of models. They can give explanations and different explanations to different people that fit the particular case we want to pull it on, but it's not the actual explanation. And when we think we understand the explanation, we are much more confident, and I think foolishly confident in some subset of cases. So our own view is that there's a real risk of narrative fallacy here. And we should instead just be open that maybe there are times when explanation is not that important. I use the example of aspirin often. We know that aspirin works really well. We have no idea how or why aspirin works. There are forms of knowledge and epistemic certainty we can draw from things other than explanations. And in some instances, we should settle for that and be honest that that's what we're doing rather than trying to go back and kind of create this in a slightly different way. Okay, I think this really is my last slide, and then I'm going to stop, which is to say, I've given you a lot of problems, but wait, there's more. And here's the more. All of this would be hard enough to figure out if you were a regulator like FDA or an internal hospital executive reviewing the medical AI and deciding whether to prove it and let it go. The problem is that that kind of medical AI, which is locked, is leaving a lot of value on the table. As your patient population changes, as it's used in a new place, you want it to learn. You want it to fill in the gaps. You want it to basically collect new data about different racial groups or other kinds of groups, and as a result, do better. That's what we call an adaptive algorithm. The problem with an adaptive algorithm, though, is how do you know when it's changed enough from its factory settings, if you will, that it's time for regulatory re-review or re-review by a hospital system? How well can we know this? How incentivized are companies to share this? And how can regulators who are having a hard enough time getting their arms around simply the question of locked AI also impose a system of checks and balances that goes forward in time? We have a few ideas in this paper and we can talk about it, but I think it's a wickedly hard problem, and I want to acknowledge that. Okay, last thing I'll say, I guess I have one more slide. Maybe I'll save this one for the Q&A. What, if anything, is different from ChatGPT and LLMs? And I'll just run through this real quick. One is that we have to worry about a new kind of privacy, which is prompt privacy. That your doctor starts typing in information about you to try to help him into ChatGPT, and ChatGPT and others suddenly have information about you. There might be a possibility of sandboxing AI, and we can talk about that, but this is a real problem. We've already seen this in other industries. Another thing, and I've alluded to this, with chatbots, it's very tempting to use them to interact with people. And how are we going to disclose to people that you are dealing with a chatbot? Third is medical deep fakes. It's very easy to create fake medical data and fake journal articles, like a fake New England Journal of Medicine article that looks just like a real one with fake citations that shows that the COVID-19 booster that some people are taking right now causes sterility. The problem of oligopoly and foundational models, that a few largely private industries are building most of the large language models we're seeing, and the idea that whatever they decide may become standard and adapted and built in, including biases. Environmental effects, It turns out large language models are extremely carbon expensive. They're wasting a lot of resources, and they are doing this for what benefit is the question. And you can ask a quick question, or your nephew can basically get some help with an essay that they are writing. How do we internalize the carbon concerns here? And finally, one piece of good news, because I want to end with some good news. There's a way in which, compared to the rest of medical AI, it turns out ChatGPT and LLMs actually are more likely to empower patients. They're more likely to be directly available to patients. That's positive in some ways, negative in others. But if our goal is an empowered patient, it's possible this is a really welcome thing. All right. Thank you to my sponsors, and I'm going to stop there.
Well, thank you. That was full of information. Wow. You went through quite a few of the issues, but I'm wondering, I guess I see that we at least have one question in the chat. So let's look at that. I work for Washington State Department of Health. If we turn on a feature for a system that has a proprietary algorithm, so no one actually knows what it does, do you think it's possible that the state could be held liable for patient harm as we chose to activate a feature it could not validate?
Okay, so this is where I get to say I'm not licensed to practice law in the state of Washington or give you legal advice, so nothing I say constitutes legal advice. Okay, that said, as a state, you also have a whole set of doctrines that may protect your sovereign immunity in some ways. So maybe you're better than the average one. But I would say the liability here faces and kind of connects to your moral responsibility. If you really kind of don't know what the proprietary algorithm does and you haven't tested it and you haven't started with the pilot and built your way up, the possibility of kind of causing harm to patients, even if they're never successful at suing you, is like a real problem and is something that you should sort of think about pretty seriously. Now, maybe there are benefits. I always tell people, I give these gloom and doom talks. I say, AI might be biased. AI might make errors. AI might invade your privacy. But guess what? So do physicians. Physicians make a lot of errors. Physicians are highly biased in certain ways, and physicians talk to each other in elevators and say all sorts of things about patients when other people are sitting around. And really the question is, as compared to what? Do you have confidence that the medical AI will do better? And what gives you that confidence? And how have you studied the question? Those are what I would put the question, and who's going to decide this? And have you kind of also involved the patient groups who are most likely to be negatively affected in the governance conversations and governance decisions? That's what I would kind of leave you with on that question.
Can I ask a follow-up?
Sure.
Yes.
So
boss, yeah, go ahead.
This is you've probably heard of Narcs Care before. This is specifically about Narcs Care. It's a feature for PMPs, and there's concern, especially from pain patients, that people with legitimate needs will no longer be able to get their meds. I have concerns, but AI is shiny and new, and I'm not sure that everyone at the state is concerned with that. So I'm just kind of looking for ways to caution, when we take on this kind of work. And I'm curious if you have any like best practices or anything. Like, we don't have any sort of internal AI review process, which I think is like a real misstep for us, and we need to kind of get something in place, but I don't have that much power. So yeah, I'm just wondering if you have tips or anything.
First of all, I want to say great for you for kind of being concerned about this and like a model of kind of this idea that just because, a government is doing something, if you're a person with, concerns, how do you elevate that? So one thing I'll direct you to, there's a really good thing called the Algorithmic Fairness Playbook. I think it's by Chicago Booth. They developed it. It's kind of designed at the level of C-suite executives or government decision makers. And I can find the link and I'll put it in the chat in a second. And they kind of try to say, let me take you step by step by how you should do an audit of an algorithm for fairness in particular. And that's a little bit different than doing other kinds of audits, but concerns about fairness. The other thing I'll say is that there is work on what's sometimes called human in the loop, which is the idea of having human review of certain things. Where it gets complicated is people are often very fond of human in the loop as a solution, but the result that human in the loop improves performance is actually a somewhat fragile response, and that there's some circumstances where adding the human in the loop does better than the AI. There's other instances where it does worse than the AI, and there's some where it does worse than even the human without the AI. So this is the thing where I think it's like important to study. And the risk profile matters a lot. Like, in a case where what the worst thing that will happen is the AI chooses to offer free stuff to the wrong people, I feel very different than in a world where the AI kind of directs somebody who really needs care away from care, for example. And so I think it's worthwhile to kind of think about risk classification. But I'll find the algorithmic playbook and I'll put it in the chat. It's worth taking a look for, and it's well written for, I think, the kinds of people you want to influence.
Right. Thank you. We have another question here. Fantastic talk. You mentioned earlier in the presentation about potential regulations, and I'm curious if you could expand more on this view on your personal thoughts. Do you think medical AI warrants a new regulatory body or approach? I agree FDA seems not an ideal fit, especially because focused on developers, yet HHS attempts to enter the space also don't seem perfect, since more focused on the end user hospitals and clinicians who may not have the power to really scrutinize the algorithms they're using.
Yeah, so let me start at the end of the question, then we're going back to the beginning of the question, which is to say, I think any system that says the solution is that physicians will have to understand the algorithms they're using and make wise decisions about that is just bound to fail. Physicians are busy people as it is, and physicians are asked to do so much in our system, as are nurses and other healthcare workers. I mean, healthcare workers generally. The idea that we also want them to become data science experts and curatorial about this just strikes me as wildly unrealistic and also puts an unfair burden on them. So I definitely want to move a lot of the curatorial regulatory space one level up. I think when it comes to hospital systems, really hospital systems need to identify a group of people within their hospital system to do the really wise auditing, purchasing. And I can tell you the large academic medical centers have these kinds of people, in part because they're also developing the software as they go. But I think it's very hard, especially for under-resourced centers, where sometimes the AI can have the most large positive benefit to really make these kinds of wise decisions. So I would love to see more curatorial work, even if it's by third parties, like the equivalent of JCI, the Joint Commission. But for that, that would get us some of the way there. In terms of FDA versus other agencies, or here's what I think. There's some problems that cut across multiple types of AI. I think some of the questions about antitrust, competition, oligopoly, even some of the privacy stuff, I think inferences, and even maybe some of the discrimination stuff, I think is probably worthwhile for a general regulator to set rules about all kinds of AI because the problems are similar enough. But when it comes to examining performance and integration into the healthcare space, I don't think you want a general regulator to do that. I think you want someone with some expertise. FDA, as I said, has been more open to it, but partially they're hamstrung by Congress, who in the 21st Century Cures Act removed a lot of their authority over some kinds of medical AI. And as a result, I think we now have quite a vacuum in the United States that's either going to be filled by tort law, I think unlikely, or possibly filled by private actors and by kind of contracting. Will that be a better solution than having beefed up FDA? If you told me I could add 500 people to FDA and that I could kind of have them focus on this problem, I think FDA would do really well. But given the volume and the variety of medical AI and the complexity of the individual ones, I'm just not holding my breath that they're going to get resourced to the point where they can expand what they're already doing, which is looking very carefully at a small subset. And even then, I think there's interesting questions about whether the systems in place that they're using to try to determine this are right or not. I'll just say one more thing and then I will shut up on this question. Sorry, going on a little bit long on one question, which is just to say, if contextual bias, that is the idea that something, and this is a term my friend Nicholson Price uses, the idea that medical AI trained in one setting and showing that it works is no guarantee it works in another setting because of differences in resources, differences in patient populations, differences in kind of healthcare style, differences in workforce management. If that's true, then a regulator like FDA has an even stronger problem to face, which is they can look at the study that's submitted, but if the study that's submitted from one hospital system or one care setting really has very little purchases to the other, it may mean that what we really need is to be doing lots more randomized trials at the level of individual hospital systems before things are implemented. And if that's true, that's just a very onerous kind of undertaking. And so for me, I wouldn't want to do that for just any old AI. But when we really do think that there's a real risk here, that I think is the gold standard of what people should try to do.
Thank you. Thank you for your questions as well. We have another question about hospital ethics committees. Do you think that they have a role when their system is considering AI initiatives? Is this in part a problem of institutional ethics?
Great question. From a questioner I know who I worked with on some digital health stuff once upon a time. So here's what I would say about this issue. I think ethics committees would be great, or some combination of institutional review board, ethics committees, and the like would be terrific to get involved in the setting. I will tell you in practice, who constitutes those groups are probably closer to what the patient perspective would be, but maybe very far away from what the hospital CIO perspective would be. And some of the questions strike me as kind of really within the bailiwick and with the expertise. For others, I'm a little less certain about how easy it would be to get up to speed on some of the questions, right? Especially if there's questions about performance or re-identification risk. There's a world where, you know, you bring in the experts and they explain it well. And the ethics committee or the institutional review board is pretty good at deciding these questions. And maybe there's a subset of questions about that, but that would be my biggest worry. I do think, though, that ethics committees and institutional review boards, perhaps to a lesser extent, though, have a big role in thinking about the design of governance structures. And so community advisory boards, for example, which is something we see in some areas of medicine for all in this space, I do think that kind of, if I was, I'm gonna put it this way, if I was doing something with a rare disease group and it involved medical AI, or if I was to use the other example, Narcan or something like that, and I was using that patient population and doing something for them, one of the first things I'd want to do would be to charter a group of people who have the perspectives of those populations and find out what they're worried about and find out what their questions are. Because trust is so hard to earn and so easy to lose. And I do think there's a way in which ethics committees and institutional review boards are really the vanguard for institutions about losing trust. And then it's really important to kind of, in that function, to make sure the patient voice is being heard. But some of the questions, just to be honest about it, I think are at a level of complexity that might befuddle some members of those communities, at least for the IRBs and the ethics committees I've kind of known in my time.
I don't see another question at the moment, but I'll take up the moderator's prerogative and ask something. So what about the possibility, or do you see the potential for medical AI to kind of fill gaps in medicine that might otherwise be criminalized in certain states? So medical AI enabling reproductive or abortion procedures, or some trans affirming or mental health care for minors, and or as well as the particular privacy concerns facing providers who may use AI um, in those areas.
That's a super interesting question. I talk about this a lot. No one's ever asked me that question yet, Professor Hoffman. So here's a very rough cut as an answer, because I think it's really interesting. I want to think about it some more. There is a big debate. We've seen this a little bit in the ChatGPT space, a big debate. There's an emerging debate about professional speech and how to think about the speech of ChatGPT in the context of both state actions of First Amendment kinds of issues, but also in terms of when it becomes the practice of medicine and professional, right? So when it becomes licensed, the kind of thing that only a licensed professional should do. And so for me, I think my instinct is there probably is a line where ChatGPT stops giving you resources or kind of giving you paramedical kind of help and advising in these contexts, and actually crosses the line to giving medical advice. And it would seem odd to me if the law said, an ordinary physician could not give that piece of medical advice, but ChatGPT could, and the ChatGPT is doing this, and you do nothing about that, and that's the end of the matter. That would seem like a very strange outcome or set of incentive structures. So my instinct is that probably that's not right. But until we get to that line, I do think there's a possibility here, especially about kind of federated learning and decentralization, that there's some advantages here. Now, I'll put my civil procedure hat on. I think there's also very interesting questions about where jurisdictionally for extraterritorial application and personal jurisdiction, and also choice of law, ChatGPT is when it generates an answer to a patient in another state. So that's another great question that you suggested to me that I hadn't thought of before.
Oh, civil procedure. Oh, okay. We do have a couple more questions here. So, thank you for your talk. As you mentioned, healthcare providers do not have time to become data science experts, but wouldn't the integration of a medical AI create the possibility of over-reliance by healthcare providers in patient treatment? You highlighted that AI is still prone to inaccuracies or biased outputs. Providers lack the time or focus to back check every decision and output an AI puts out. So wouldn't this create liability if the AI puts out an ineffective or unsafe recommendation that a busy provider automatically followed to the detriment of the patient? Who would be liable in this case, provider or AI?
So I think that if the standard of care, and this is the question of the standard of care that I kind of had a few slides ago with the color-coded chart. If the standard of care is to do X and the AI says do Y, and you don't check, and you put people on the stand, they say any physician in the right mind would have done this. It's not a defense that I had 7 other patients. It's not a defense the machine has been beeping at me all day and I overrode the other 6. And the 7th one, it turns out I shouldn't have overridden, but I did the same, right? I think we're asking people, and this is one of the reasons why I said that I think part of the problem might be over deterrence of use of medical AI. And the problem now, all that said, as people who do medical malpractice will tell you, right? There's a bit of a crapshoot about whether you ever get sued, whether if you are sued, the case is settled, and if you are sued, if it goes to trial, what the result is. So people who study medical malpractice and compare, have experts look at cases and find out which ones paid out and which ones didn't. What they find is a very noisy system. Physicians tend to be heavily insured against medical malpractice. That doesn't mean getting sued is not awful. And as cases go, these are fairly unattractive cases to bring as a litigator, I think, in part because proving the causation and proving all the data and proving what was right or wrong is an extremely kind of big undertaking, especially when many of these companies will try to interpose defenses of trade secrecy, like we've seen on the criminal justice side by some of the people who are making offender sentencing. So I think my own view is it's not just coincidental or a reporting kind of a function of reporting that we haven't seen a ton of cases yet. I think these are cases that are fairly unattractive to bring. And if anything, at the end of the day, and I feel bad that I always start with liability, I actually am more worried that people are, because of fear of liability, will have under adoption than that I think that they'll have too much adoption of this. But I could be wrong. That's just an empirical hunch based on what I know about medical malpractice, but it could be totally wrong.
Okay, now we're getting to some more here. So would you care to comment on how to ensure that medical AI will be governed by quality and in uniformity of patient care and outcomes across all patient groups, rather than maximizing profit, which some may attempt to sneak in under the guise of a proprietary black box algorithm?
Yeah, tough problem. So here's kind of my kind of overall reaction. One is more public funding and publicly funded work in the space to compete with the private sector, more government oversight and regulators and watchdogs looking at what's adopted and why, and more publicity and more ProPublica reporting on kind of the ways in which these things are adopted and made. We saw this to good effect, I think, in the criminal justice system, which was an early adopter of AI. It hasn't completely worked, but I think there's a lot more chastening of people's kind of desire to adopt AI in the criminal justice system than there would have been in the absence, especially of that kind of journalistic focus. But easy to say for me to do it, very hard for the average journalist to get inside the hood and to really get this answer. We've seen some bright spots like the Pixel kind of litigation and the like, more on the data privacy. But I do think that in this case, sunlight is the best disinfectant.
Let's take one more question. We're about out of time. What about AI in rural regions that have very limited clinical providers? Do you think that there should maybe be a different standard, or does it differ is it different from Dr. Google?
Yeah, so great question. Another very nice to see in the chat. Here's what I'll say. There are some cases about medical malpractice for patients that are kind of, being on publicly financed insurance or poor patients. There were, periods of time there have been proposals that basically we should have a lower medical malpractice or a higher medical malpractice litigation kind of hurdle for those patients to kind of make up for the fact that we don't want to discourage people to give care to people who are deeply in need. And there are some spaces like charitable immunity when there's an outbreak, for example, in the public health setting where we do have some of this along the sides. But my own view is like, no, if you are in the United States, you deserve good care. And if it would be bad care at Mass General, it should also be bad care in a rural hospital setting. That said, in some states, the standard for proving medical malpractice is local custom. And if local custom is different, that might make a difference too.
Right. Well, I know we have a few more questions, but I think we are out of time, and you've had a lot to say. A really fabulous talk. I want to echo what a number of the audience members have said. So thank you so much for really very thought-provoking and comprehensive presentation. And we're just so thankful that you've kicked off our speaker series for this academic year. So thank you so much. And thank you to all of you for showing up. Take care, everyone, and hopefully we'll see you next time. For Nida Farahani, look for on the AI and your brain, and please look for an announcement about that session. Take care.
Thank you.
Thank you all.